Friends, y'all go ahead and continue eating, but I'm going to go ahead and introduce Daniel, our presenter today. Daniel is a lawyer at Faulkner Law Firm, and he doesn't have a specialty, so to speak, but he does work a lot with estate planning and what was the other big word?
Estate administration, civil litigation.
All those things, right?
General civil practice, but heavy on the estate side.
Many of y'all know Daniel, but for those that don't, he is a generational York kid, and went off to college, came back with his law degree, and practices here in York. We'd love to see that. We'd love to see locals come back and raise their families here. And so we're grateful that you're able to come and speak to us a little bit about a topic that not everyone always likes to talk about, which is estate planning and planning for the end, so to speak. So appreciate you being here. Take it away.
Well, thanks for having me, and yes, it's nice to be able to come back home and work, and been part of the community here in York for my whole life, and then my dad before that, and his dad before that, and we go all the way back to when it was not York County, but York District, back in the colonial era. There's actually a Daniel Harshaw buried at Sharon ARP Cemetery, so we go all the way back, so to speak. But talking to you today about estate planning. So what is estate planning? And by the way, if you're having trouble hearing me, let me know, or if you have a question, feel free to interrupt me and I'll try to address that. But an estate plan is directing what to have happen with your assets. And that can be during your lifetime, that can be at your death. So you have things like a last will and testament. I bequeath this to this person and this to this person, or a trust that leaves things with more controls. And you should also include people who can manage your assets during your lifetime, because there are things that can come up where you aren't able to manage your own property anymore. So having a successor trustee, a durable power of attorney in place, naming an agent who can take care of your affairs, and so it's all about managing your assets and your person during your lifetime and thereafter. So that's an estate plan. And why make one? Well, it's to protect your loved ones, to protect a spouse, to protect children, to deal with the difficulties of age or the surprises that can arise at any time in life. And failing to plan it can leave a real mess. I've got plenty of clients that own houses together with young children because their spouse died without an estate plan. And so a child inherited half the estate or a fractional interest in the estate under the laws of intestacy. And that was not what the parties intended. But last will and testament names who's going to get your property when you pass away. It does not control anything during your lifetime. A lot of people think, well, I've got a will, I've named someone in that will to control and be over, and so if something happens to me, they're going to step in and manage my... It doesn't happen that way. The will is not effective until you have died. So if you've had a stroke, if you develop dementia, who is going to be sure that your bills are paid, that you get to the doctor, that you're in the place that you need to live? But the will names who's going to manage those final affairs, goes through the probate process, is administered through the probate court. That process generally takes a year. There's a creditor claim period where anyone who claims that you owe them money can present that claim in the court. If you have minor children, or if you have someone in your life that cannot care for themselves, that's your opportunity to name who would be over that person. A guardian, a conservator. You might set up a trust for minor children or minor grandchildren. If you haven't picked up, it's a very important thing for those with children. Where, Nick, where's yours, right? Because you don't want to own a house with a child. You don't want to leave that child to chance. A trust is a legal entity that holds your assets. You can fund it during your lifetime. It's a lot like a last will and testament in that it can control where assets pass after you've passed away, but it also can control those assets during your lifetime. most of the time when people set up trusts, they are their own trustee, and they manage their property for their benefit, just like it's in their name individually. But it also helps if you become incapacitated, have a stroke, develop dementia, and can't manage things on your own. You can come out of the trustee role, and another trusted person, spouse, child, whomever that needs to be, can direct your assets during your lifetime, but also keeps your assets out of probate when you pass away. So if you have a piece of real property that you don't want your children to have to wait a year and deal with creditor claim period, they can deal with that piece of property immediately. Now, you can distribute a piece of property out of an estate immediately, but it's still potentially subject to creditor claims while that claim period is running. So it might be out of the estate, but there are certainly ways to claw it back in. It's not a pleasant process, but sometimes it has to be done. But it's very flexible. It does what you want to do. Well, I want to leave this to my spouse for life, and then remainder to my children, so that because I'm in a second or subsequent marriage, I want to provide for a spouse, but I don't want that spouse's children to inherit everything that I had when they pass away. I want it to end up with my children. And so that's a great way for a trust to manage your interest in property also. Or it can be, I have a child that should not get all of their inheritance at one time. Maybe it's they are young. Maybe it's they have life issues and just aren't good at making decisions. They're 50 years old but never grew up. Those situations exist. Trust can provide for that. I've drawn those before. Had people say, well, I want to be sure that they have a job. They're going to inherit a lot of money from me, but they just won't work hard. Well, we'll set it up so that their share, they'll get a match based on their earnings, and the trustee will say, well, where's your pay stub? I'll match it. You're going to have a job. Whatever you need, you can do through that trust. It's flexible. Durable power of attorney.
Before you leave, can I ask a question?
Certainly.
It says the trust holds the title to your assets. So how do you
Yes.
get something into the trust?
So there are many ways to do that. Like with your house, we would do a deed from you or you and spouse into the trust. And it might be the whole interest in the property. So it might be joint trust, joint ownership of the house, and just one deed in. It can be, well, because it's a subsequent marriage, well, there's a his trust and a hers trust, and we do half and half, but then it can be bank accounts can go into the trust. Now, bank accounts really can't be divided like that, because if you have signing authority, you can operate any way you need to in that account, including drawing it down to zero. So there's things to think about. You can put your car title into trust. I generally don't advise that, but that's a way that you can prepare in advance. The biggest thing is being sure of your real property, and I do a bill of sale to put untitled personal property into the trust. All the stuff in your house, farm equipment, tractors, you don't have a title for your tractor, but you would for your truck. Well, the truck might sit outside of probate, but the tractor will put into the trust. So generally, you kind of have to get specific advice on what that asset is, how to put it into the trust. But you do want to be sure that your assets are in. Business interests. Own an interest in an LLC. You want it in trust so that that membership interest doesn't pass through probate.
Question, what's the cost of the trust that you make? We come to you to make a trust.
It varies greatly, as you might imagine, but it starts at $2,800, and that's a trust package. But
Okay.
yeah,
Another question.
yes, sir.
Stocks and bonds and that sort of thing, should they be put into a trust?
Yes. So generally, those get held in an investment account through a brokerage, and you can retitle that brokerage depending on how you own it. So if you own it in a retirement account, 401k, IRA, you actually cannot put that into your trust. It has to stay in your individual name. But if it's a separate brokerage and you just have separate investments, this is after-tax money going in and it's kind of my savings is in the stock market, then yes, you can retitle that into your trust. You can also designate that by beneficiary designation, whether it's into trust or to beneficiaries. Durable power of attorney, already talked about that some, but that is who steps in and manages legal and financial matters on your behalf. So if you are unable to or unavailable to manage your own financial affairs, when I draw a durable power of attorney, I generally draw it to be effective immediately so that your agent doesn't have to prove that you're incapacitated. You don't want to have to go to the bank and say, okay, well, my parent has now had a stroke and can't come in and do this. You want to be able to go in and handle business and not necessarily publicize whatever has happened to you all around the community. Just, hey, I am the power of attorney and I'm going to step in. There is a springing power of attorney. It springs into existence at the time you suffer that incapacity. And oftentimes people say, well, isn't that better? Nobody can manage my assets while I can do my own. But what I say is, in that situation, if you don't trust the person to manage your assets the way you want them to be managed, do you want them to manage your assets when you can't monitor what they're doing? So be very careful about who this person is, because they hold your financial life in their hands. Now there's healthcare power of attorney, and we'll talk about that in a minute. They hold your physical life in their hands, but the durable power of attorney ends when you pass away. So we've talked about the will picks up the moment you die. Well, the power of attorney expires when you pass. So you think, well, my power of attorney is going to go do X, Y, Z as soon as I pass away. And maybe they do, but it's not legal. They might get in trouble, maybe not. Depends on what they're doing and if everybody agrees and other situations, but they might not be able to. So you might think, oh, they're going to go to the bank after the funeral, but the bank has gotten notice from Social Security because your death certificate's been filed and they know to reverse Social Security payments, so they've put a block on your account. Power of attorney can't act anymore. Healthcare power of attorney is the person who steps in when you can't make your own healthcare decisions. We talked about a springing power of attorney. This is always a springing power of attorney. And that makes sense because your healthcare provider is going to know if you have capacity to make a decision or not. You should be present when they're making that determination. You should be there. So this is the person who decides what health care treatment you need, into a hospital, out of a hospital. You make elections about organ donation, about life-sustaining treatment, about feeding tube, and very specific scenarios in that. But again, it's the person that you trust with your life to make decisions on your behalf when you cannot make your own. So, as you might imagine, I'm a proponent of everyone having a will, everyone having a durable power of attorney, and everyone having a healthcare power of attorney. Well, of course, I draft them, right? Well, I make more money when you don't have them, I'll go ahead and tell you. But I prefer to draft them on the front end because it makes life easier for your loved ones, for you, when those situations arise. Living will. And people think, well, what's the difference between a last will and testament and a living will? I've got a living will, right? Well, a last will and testament is dealing with your property after you've died. Living will, the statutory name for that document is Declaration of a Desire for a Natural Death. It is, I want to live my life free of machines. If I'm only being sustained by machines, if I do not have hope of recovery, do not hook me to everything imaginable to keep me alive. That's what the living will says, okay? So if your condition is terminal, incurable, irreversible is the type of situation that you're thinking about. Now, this doesn't mean that you decline hospice care, palliative care, whatever that looks like. But if there's nothing else that can be done, then it's saying, don't have me connected to everything and make me suffer longer than I need to. And in this, I like to always name an agent, and generally that's the healthcare power of attorney, to enforce the document, Doctor, you said that everything that could be done has been done. The family has come in, said goodbye. It's the difficult time. This is what Mama wanted. This is what Daddy wanted. It's time to unhook or revoke. Well, doctor, didn't you just say that we could do this procedure and if there's a chance? Let's try that procedure before we decide if we're gonna disconnect. You're not gonna do that while they have a living will? I'll revoke it for that procedure. Then there's some other ways that you can avoid probate. That's ownership of property. You can own as joint tenants with right of survivorship. And so that's how I recommend husband and wife to own title to their house in most situations, unless they have a trust that's holding it. But that way, and generally, guys, we go first, right? And that's the way statistics kind of tell us it's gonna go. Are you gonna leave your widow going through probate as to your half of the house? Joint tenants right of survivorship, that does not happen. That helps protect your house from creditors. Not that they can't get to it, but it's harder. And it's immediate. The other form of joint ownership that's statutory is tenants in common. If your tenants in common, when you die, your interest in the house or whatever that property is goes through probate. So joint tenants right of survivorship avoids probate. It's immediate. You file a death certificate in the Register of Deeds office, it's done. But you have to be careful because that can short circuit your estate plan. If you own your house, joint tenants right of survivorship, but you have a his and hers trust because it's a subsequent marriage, you just short circuited your estate plan as to the house. So be careful about it, but that's out there. There are other ways that I'm not as big of a fan of. Like in North Carolina, they have something called tenants by the entirety, where husband and wife own property together. Well, South Carolina doesn't have that. But we do have tenants in common with the indestructible right of survivorship. But it's created by the courts, so it's not as predictable as the statutory ways of owning title to property. Well, when it comes to a big investment, you want predictable. There's a place for the other forms of ownership. Medicaid planning. Everybody always asks about this in this situation. What about Medicaid? If I go into a nursing home, and I'm not really a Medicaid planner, that's not an area that I focus in on, but let me tell you a little bit about that so that if you think that that's something that you want to plan for, you know some questions to ask. You can only have $2,000 in countable resources. You spend it way down, all right? How many of you have multiples of that in your checking account right now, in retirement account? You can't exclude your house, you can't exclude a car, but you're talking about having spent all of your cash. Well, let me just give things away right before I need to go into the nursing home. Well, they look back for 60 months. Have you gifted things away? And if you have, they count a penalty period back against you. And that's why I don't do the heavy Medicaid planning, because it's high liability. You mess up, you're talking about up to 60 months of nursing home costs at 6, 7, 8 more thousand a month. Very, very, very expensive. And then income tax consequences. If you gift assets over, that gives your beneficiaries of that gift a carryover basis. Do you know what tax basis is? Essentially what you paid for the asset, or what Uncle Sam says that you paid for the asset when you sell it, he charges that tax bill. So imagine it's the family farm that has been in the family for generations and, you know, traded beads with the natives when you got it. And I've actually encountered some of that in some properties. So the tax basis is nothing. If you gift it over and then they sell that asset, it's all income taxable. If they inherit the asset, which goes against the Medicaid plan, they get a step up in income tax basis. They get today's or your date of death value for income tax purposes. They inherit a $2 million farm and sell it for $2 million, and so that they just sold it for tax basis. No income tax gain. But a lot of very specific situational requirements when you plan in that. The other thing to think about is long-term care insurance. If you have an investment broker, they probably sell that. If you have an insurance agent, there's a good chance that they sell that. It's expensive, but if you need it, it pays out a tremendous amount of money. It's not a perfect solution, but sometimes it buys you the 60 months to do the plan if you're in that situation. Personal care contract. That is a tool that we use to help when there's a child who's taking care of you and you're trying to spend down your resources. Well, they can step in and they're providing substantial care. They're making sure that you got meals, that you're taking baths, that you're up out of bed, back into bed, that you're getting to doctor's appointments, those kind of things. All that heavy lifting, that big burden that can fall on a child, well, you can compensate them, but you need a contract in place when it comes time for Medicaid to show this was pursuant to an agreement. They're providing services to me. I'm compensating them fairly for those services. This isn't just a gift. So there are things to be aware of in those situations. When to make an estate plan. Now, if you don't have one, you need one right now. But there are times to go back and revisit those. When you have young children, you need to be sure that they're protected, that your spouse is protected. And that doesn't mean, oh, well, I'm going to make a will and leave everything to my brother or my sister who's going to take my children. You leave your assets for your children in trust, even if it's through a will, call it a testamentary trust, so that if your brother or sister goes through a difficult life situation, a divorce, at fault in a car wreck, your money's not at risk. If it's in trust and they are just the trustee of the trust, then no one can reach it unless there's liability back through the children. Well, you can put in provisions to protect from that too. But you don't want to leave a spouse owning your house with a toddler and they can't sell, they can't refinance without going and asking the court for permission. Terrible situation to be in. When your children become adults, well, you probably have named other people in your wills as the people who will be the administrators of your estate, who will be over your children. Well, once they become adults, do you have children who can step into those roles? Take that burden and put it back into the family where it can be dealt with a little bit more broadly. When you have complex family situations, subsequent marriages, blended families, children who need to be protected from themselves. I'll tell you, one of the first things I encountered as an attorney was a situation where a young man received a large settlement because he was in a car wreck. And it was administered through the courts because there was not a good plan in place to provide for him. And he received millions of dollars on his 18th birthday. And he did not make it to 18 years and 1 month. That money killed him, quite literally, in that short of a period of time. So protect your loved ones with an estate plan. Keep them from feeling like they need to fight inside the family. Lay out what you want to have happen with your property during your life, after you've passed. Anytime that you're getting remarried, adopting a child, if you're the standard nuclear family, husband, wife, shared children, once you have the estate plan in place to provide for the children, you're okay. But let's say you're older and you adopt a grandchild, or you remarry and adopt a member of new spouse's family. It's a good time to come back and revisit and be sure matters are taken care of. Another horror story for you. Man did a will, but then he remarried and he adopted a child. And so his estate plan didn't properly address the situation. It was a difficult situation. The family got along okay until they got to his estate plan that really pitted them against each other. They had little choice but to fight at that point because the issues were complex. A widow who needed to be provided for, a minor child who was omitted. So dealing with those situations. And then if you are going through a divorce, revisit your estate plan. All right. Who all do you need to talk to about your estate plan? Well, attorneys, obviously, we're going to be the ones that draw up wills, powers of attorney, trusts, those kind of things. Financial advisors. Do you have a brokerage advisor or some other financial advisor to tell you how to set up your accounts? You need to set this up. These are beneficiary designation forms, so you can name a spouse, you can name children as beneficiary of these. And if it's retirement money, that's very important. If it is beneficiary designated to a person, think about when you're pulling money out of retirement, you're paying income tax on that. Well, your beneficiary will need to pay tax on that money as they receive it. That's one of the exceptions to the step up in tax basis. Uncle Sam's gonna get his cut at some point. So if it's to an individual, if they are a spouse, they can take the money out of that account over their expected lifetime, the RMD. If it's to a child, then they have 10 years to take that money out. If it's left into your estate or into a trust, and sometimes this is worth taking the hit, you get 5 years if you do it right. And I say if you do it right because often it's not done right and you end up paying tax all in 1 year. Think about what you've got in retirement accounts right now. Hundreds of thousands of dollars. If you can split that up over years, push it down income tax brackets, use personal exemption to protect that money, you can reduce your income tax liability. So think about that. Insurance, be sure that you have the kind of insurance that you want and need, whether that's long-term care, whether that's life insurance, that you have beneficiaries designated, that you revisit those beneficiary designations, that you keep copies of your beneficiary designation forms. Funeral planning, you can buy pre-need burial contracts. If you know that I want this funeral service, you can go and get as in-depth as you want and prepay and lock in today's prices. What if that funeral home goes out of business? They are regulated by the state on this. They have that money in special accounts, so that money will be there for you when you need it. But get resources you can trust. Deal with people that you have confidence in when you're building your estate plan. But get that team together. Don't hesitate to make those people talk to each other to be sure that your plan works together. It needs to be cohesive and work for your situation. Nobody's the same. There might be a lot of similarities, but every situation is different. So be sure you have a team you can trust. Of course, I'm here in York, got an office in Clover also, but y'all have been awfully quiet after we talked about trust. I'm used to more questions as we go. So what do y'all have questions about?
Daniel, just a comment about living wills. About 10 years ago, I was talking to probate judge Carolyn Rogers, and she said, "Do you have a living will?" And I said, "Oh yeah, we've had it for years." She said, "Well, if it's more than 10 years old, you need to update it." And which we did, and the verbiage in there was so different.
Yes.
Things like remove feeding tube was very specific. So going forward, since we have a 10-year-old living will now, when should we look at updating it again? I mean, is it something you need to do every 10 years, or is it pretty much the same for the best?
It's been the same for quite a while now. I don't know that I remember a change in it, and this is year 16 in practice for me, so it's been the same for a long time now. However, I do recommend that from time to time you schedule an appointment to sit down and have your documents reviewed to be sure. I can't tell you how many times I've said, and in your will you're leaving this to this person. Oh no, they're out now. And It's often not a child, it's like, oh, I was leaving this to a sibling and we've already settled that, whatever that is. I don't want them connected to, or I'm leaving my interest in this business or so much money from the business to a business partner or a key employee to encourage them to stay. That business has been wound up for years now. Why do I want to leave them these thousands of dollars when I need to provide for my family? So it's those kind of situations. And that's your estate plan, that's beneficiary designations on retirement, on insurance policies, being sure that that's the case.
Do you recommend revocable or irrevocable trust, and why?
It depends on the situation, but generally revocable or revocable trusts, because you have the ability to amend that trust as your situation evolves. And so as a younger person with a young family might have assets held for a longer period for children, and then they grow up and you see, oh, okay, they turned out okay. They can manage what they're gonna inherit for themselves. I don't need it locked up until they're 30 now. I'll go ahead and let them outright inherit it. But also if you have income producing assets in that trust, a rental property or something like that, then if it's in a revocable trust, it's just on your income tax return. It's not a separate tax return. If you have income producing assets in an irrevocable trust, you've made a gift of those assets, that trust pays its own taxes, and it's got a compressed tax brackets and essentially no personal exemption, $600. So you've just given a gift to Uncle Sam of a greater share of your income. Now, they're good for setting up things more than 60 months before you need Medicaid, because that's a completed gift once it's funded into that trust. But you've just destroyed your step up in tax basis in those assets. So it's a very double-edged sword there when you use that. Yes, ma'am.
Going back to the living will thing, hospice puts out a little brochure that it has to do with 5 wishes.
Yes, ma'am.
Would that be similar to the living will?
It's similar, but it's different. And so the 5 wishes is great because it's more in-depth what you want in various situations. But it's not necessarily legally binding, okay? That's
And
where,
even if you have it notarized?
even if it's notarized, because it's not specifically authorized by statute. And that's one of the things that there's been a lot of talk about amongst attorneys in the probate bar. Why do we have this healthcare power of attorney and living will that have very generic decisions that reference medical terms that are now outdated, when there are these great documents like the 5 wishes and others that express our desire in much clearer terms, but that it's not necessarily enforced. Now, does that lay it out so that people who are making decisions on your behalf have a lot easier time? Absolutely. I'm a big fan of the 5 wishes documents because you get to very expressly put in writing so that when you're not able to speak for yourself and that situation comes up, well, this is what mama wanted, this is what daddy wanted. Here it is, I'm gonna hold it in my hand, I'm gonna reread it, and then I'm gonna tell the doctor. And it's not me deciding for them, I'm advocating what they told me to advocate for them.
So if you have one of those 5 wishes, should it be updated on a regular basis?
Yes, revisit that, because as life changes, your wishes change, right? As a young person, I'm probably going to request a lot more effort be put into reviving me than if I'm 80 years old or older, or whatever that age is for you. So I've got young children dependent on me. So if I can survive, I want to survive to provide for them, but if I'm only going to be a burden, well, let me go ahead and go. They can get that life insurance policy and other things. So, but having both in writing, but having a discussion with your agent so they know what you want. And so when they have to act, that your voice is ringing in their ears, you know, don't let me linger on this. Don't do this, or don't pull the plug too fast. Whatever your wishes are, they need to know. To go back and talk just a little bit more, don't want to turn this too much into an advertisement, but I know that there are flyers for the endowment back there, and distributions from retirement accounts and beneficiaries from retirement accounts. If you are making charitable contributions during your lifetime, that's a good way to support the causes you want to support. Hey, I want to give money to my church, to this charitable organization in the community. And so you can direct your monies coming out of retirement directly to the church or directly to that charitable organization and avoid any income tax on that money. It's a good deal, right? You get the benefit of being the contributor on the money, but you don't have to pay tax on it. And actually avoid tax altogether on that money. It just doesn't end up in your pocket, but it ends up where you directed it to go. So that's a good way of handling that. But then if you have a substantial amount of retirement and your family doesn't need it for their survival and you want to help charitable causes, if they are designated for a portion of that account, then that's a good way to lead that. So whether it's beneficiary designation or bequest in a will, or if it's a direction in a trust to provide for that charity, that can be done also, and there's some tax savings for doing that. So if you have appreciated assets and you're giving them away in your lifetime, if you're giving them to a charity, that can be a good way to protect that income.
May I ask one more question?
Certainly.
Is it okay to designate, for example, my children, I put, let's say, 40% to each, and 10% to this, and 10% to the other? Is that okay?
Right, and so as long as it's clear who those beneficiaries are, and so 40% to this child, 40% to that child, and then the other 20% divided up this way. But be sure that you have the correct legal name for your beneficiary. So if it is to an endowment, work with whomever's over that endowment. If it's to a charity, be sure you've got exactly how they need it to be designated. Because I've seen where those beneficiary designations are not clear, and what should have been paid out in a week's time or 2 weeks' time was held up over a year because there was squabbling about who had the authority to sign. All right, well, I appreciate your time and attention today, and if you have questions that you don't want to ask in front of the group, I'll hang out for a few minutes.
Thank you very much, Daniel.